Happy Monday, everybody. Mm, I know that we have a lot to talk about, so I'm going to, I'll just kind of get right to it today. Big topic, one I get a ton of questions on. So here we go. All right, probably about 3 or 4 times a week, I get an email or something sent to me, with usually the question is, how can this not be steering? And then occasionally I do get some questions around torturous interference, when shops just really feel like there is a concerted effort to get cars pulled from them. And is that a real thing? So, first, we're going to get to that. But before we do, to the claims adjusters out there that are watching this, first, I want to apologize to you. You've been given a very, very hard job to do. It's the hardest job I ever had to do, and you've gotten little to no training. Like you get hired and you're put on a desk and you're kind of like learning from the guy next to you or the girl next to you instead of going through what used to be a very comprehensive and long training program about how to handle and how not to handle claims. So the first thing I want to say, and hey, shops, this applies to you as too. Voicemail is not a management nor is it a negotiation documentation tool, right? Voicemail should never be used to say more than hi, my name is. So number one, first rule, why? No one listens to a complete message but me. I'll just say that because people send me the complete messages and I listen to the whole thing. The average listening time for a message, and you know that you do this personally, is around 10 seconds. So you can leave these long voicemails because you think it's allowing you to communicate what you're supposed to communicate. So you can check that as complete and move on in your day. And that goes for body shops as well. But no one's listening to that. So it is not an effective negotiation or communication tool. It's not a documentation tool. But because it is a known recording, because you know your voice is being recorded, you know you're leaving a voicemail, it is an admissible piece of evidence. So the longer that you drone on, and the more likely you are to say something that you regret, or you must then support the statements that you made. So just right out the gate, I get to use these voicemails a lot and they're really good for me. But right out of the gate, your appropriate voicemail would just be, hello, my name is Kristen from State Farm, and I have the honor of handling your claim. And I'm looking forward to speaking with you soon. Please reach out to me when you can. That's it. That's it. That's all you want to say on a voicemail. You never want to say your car's not ready. You never want to say whatever. So let's take a listen to this voicemail first, because this is one of the ones I get that says, hey, Kristen, how can this not be steering or interfering with my contract?
Hi, Mr. Pullen. My name is Lena, reaching out from State Farm Insurance Company. I was calling to introduce myself. Your claim has been reassigned to me due to the shop that you had chosen, JBS Collision Center. It is one of the shops that tends to charge for unnecessary repairs that aren't covered by your policy, unreasonable pricing, excessive labor rates, things of that nature. So whenever that happens, the claims specialist, such as myself, have to monitor the estimates, things of that nature. And I wanted to have a conversation with you regarding that process. If you could please give a call back. My phone number is 678-935-4646, and refer to your claim number. I am in office Monday through Friday, 8 to 4:30. That is Eastern Standard Time. I have also sent you an email that outlines all of the information that I will be discussing with you. So, of course, review it at your leisure. And if you have any further questions, don't hesitate to reach out. But if I don't hear from you, I'll definitely follow back up with you. Look forward to speaking. Have a good day.
Okay. All right. That's a lot, right? And then, yeah, as a former claims manager, just like claims manager, had that email been or had that voicemail been played back to me in claims, I would not have been a happy claims manager at that point. But kudos to the fact that that voicemail is being followed up in writing with an email, recounting everything that was said. So let's just dive into this real quick to what I know everybody wants to talk about. Okay. Is it steering? Is it not steering? Well, technically, steering basically, the way I was taught is that You pretty much have to say, we're not handling your claim unless you go somewhere else, or we're not handling your claim unless you do exactly what we say. Telling a customer that there's a potential problem, telling a customer that they may have out-of-pocket expenses, is not really, it's that adjuster sort of doing their job, a little bit out over their skis, right? But they do have a duty as a fiduciary. You're supposed to put the customer first before your own interest, and you have a duty to kind of say those things. And I can remember going back in my career and having a couple of these cases where it's like I got a duty to speak up. I can remember in the early years, we always would like chew through our tongue when a customer said they were going to somewhere that maybe back then it wasn't we didn't like what they were charging, but it was like we didn't like what they were doing, right? We knew that shop wasn't fixing cars correctly. So, but steering is super hard to prove. And then even harder to prove is torturous interference. So number one, this is not legal advice. Please make sure that you communicate with your local attorney. Every state may have some case law or something that's there to look at. So we're just going to talk at a 50,000 foot level of how I used to talk to my claims adjusters about what torturous interference was, because every shop usually in our department used to scream back, I'm going to sue you for torturous interference. So this is what we used to teach them. Torturous interference occurs when someone or a company intentionally, with intent, causes damage to a person's business or contractual relationship with a third party, and it must cause economic harm. So in other words, I intentionally am trying to cost you business. I intentionally want the customer not to use you even after they've signed a contract or whatever with you. That there must be this malicious intent, and that's a key factor as we kind of go forward. But when we look at what it takes to prove a torturous interference case, there's always been these little 6 points that come up. One, there must actually be a contract with a third party. And while, yes, there are verbal contracts and those do exist, it's always better to have something in writing. The defendant must know about the contract. So does the adjuster or insurer person at the time that they're talking to the customer, do they know there's a contract between you and this person? It must be intentional interference. They must have intentionally sought to interfere with your contract, not necessarily service their own. The interference was actually improper, which means did they have a duty to do their job? Like, for instance, in a first party claim, there is a secondary contract between that person and that insurance company. Defendants conduct led to the breach of the contract. So it is solely because of what person A did that consumer B decided not to have their vehicle repaired. And then the last one, the plaintiff must actually suffer damages. And to suffer damages, those damages must be defined. You know, we hear that all the time. You can't just say, well, I'm losing business. So I can't just go into court and go, torturous interference, I'm losing business. And you go, well, how much have you lost? I don't know. It's incalculable or whatever. Um, so let's start with the first thing that is key. If you want to have any type of future, or you want to look into torturous interference, or you want to have a leg to stand on when something starts happening, you must have a contract. That is not an authorization to repair. That is not a direction to pay. You must have a services agreement. This is not mine. This is not a Collision Hub services agreement. This is from attorney Erica Eversman. Paragraph 6. In addition to the loss of that repair or the loss of that estimate, what she's done with this paragraph is also build in what all a shop loses that surrounds a repair. So you not only don't get to make that repair and have the profit that stems from that repair, but you've lost all this time and energy around that in the first place. So it just right of expectancy of damages. The customer agrees that by undertaking this agreement, the repair facility will have lost the opportunity to accept other repairs and perform other repairs by designated personnel, and that we have dedicated resources in preparation and engagement of the vehicle. In the event the customer decides to breach this contract, even if it is persuaded to breach it by a third party privileged to interfere, meaning she is acknowledging an insurer may have a privilege that allows them to interfere with this contract between the customer and the repair facility. The repair facility shall be entitled to the full measure of the cost of the repairs, not just my lost time. I can charge you for the full cost of that estimate. Plus, I can charge you parts, fees, taxes, services, charges, including for charges of towing, parking, storage, et cetera, whatever. This is a great paragraph to have in there when you are thinking about that you think you want to do a torturous interference. So if you're a shop that is thinking about going down that road. And we do have a couple of active torturous interference cases out there in the industry, and I'll get to those today. But the first thing you must have is you must have a really well-defined contract that just stipulates what you are expected monetarily because the customer engages in this contract with you. And if you just have a direction to authorization to pay and a direction to repair, then there's no definable parameters around how much money or what those damages are going to be. So if you're asked, is there a contract? Yes or no? And then what are the defined losses? How much did you lose? Can you put together something? That's why Erica has this really well written contract. You can find it on our website. You can get through it that way. You can probably also Google Erica Eversman, and I believe she even gives a speech at an industry event that is available on YouTube where she addresses this as well. So there are a lot of ways to hear from Erica on this topic. But typically, the first thing anybody has asked from a shop when they want to pursue, hey, I think I want to go after Progressive for torturous interference, the first thing that we're going to ask is, hey, do you have a contract there? And what does that contract say? All right, next. The other little part that makes torturous interference so hard is that one, the defendant must intentionally interfere and that interference was improper. And those are, we go back to like what we just said about Erica, and they may have a privilege. So in other words, you may have this contract between you and this customer to repair the vehicle, but I may have an insurer over here that has a contract to provide duties under a claim or a policy, right? And I have to handle that claim. So the adjuster has a right to be in that conversation and they have to do their job. So you just having a contract with the customer doesn't prevent that customer from doing their job. It's kind of the same as a competition. There's been a lot of tortious interference cases that have come down to competition. I'm a roofer. You're a roofer. You enter a contract with a customer to repair the roof. I have the right to try to keep selling them my services as a roofer as well. I don't just go, oh, sorry, you've signed a contract. I can't talk to you about doing your roof anymore. So there are a lot of ways that these conversations can be deemed proper. They can be deemed that they had a right. In other words, as a claims adjuster, I have a duty to explain the policy benefits and to offer all policy provisions and to offer all company provisions and benefits that we have. And then I definitely have a duty if I am aware of something that may be of a detriment to a consumer to explain that detriment in a rightful way. So I always tell shops, I used to go into shops and you guys would have signs over your desk that says, we don't do repairs for Allstate or Progressive or whatever. And you guys would tell people you shouldn't have your insurance with so and so, you should switch to such and such or whatever. And I think that's fair, right? If you don't like a particular carrier, you should say it. And it's kind of fair for the adjuster too, right? If I don't like something, I kind of have the right to go, hey, we've had problems there. Do what you will, but just know there's some problems. So that's kind of come up a couple of times. Your contract does not override the adjuster's ability or duty to do their job. So if we look at that, the most invoked and most powerful defense to a torturous interference claim is that the plaintiff cannot demonstrate that the defendant lacked justification. So, in other words, you as a body shop cannot demonstrate that the insurer had justification for inducing or showing the plaintiff something different. You may have a policy now that says that there are deductible breaks or something else. Some of you posted recently, there are policies that have a percentage offset if the vehicle is repaired outside of the repair network or whatever. So there are some reason warrants. In other words, you as a plaintiff, if you were a body shop and you wanted to do a torturous, you must need to show that the defendant intended to hurt you, not that they were trying to serve the customer. So it has to be they didn't care about the consumer. They were only trying to hurt me as Bob's Body Shop. And that the defendant did so without justification, economic or otherwise. In other words, there was a reason for it. And that's why I tell people that word gets thrown around a lot. People love it. I see it on CRTU. I see it in a lot of places. Torturous, that's torturous interference or whatever. I can tell you that it is extremely, it's extremely hard to prove, and it is a very long, long lawsuit. So this is a current, like active one that's out there. In which the shop is now being asked to describe in detail any statement in which you allege to be false which was made to any person or entity with whom you had a valid or prospective business relationship with. Your description of each statement must identify the name of the persons that made this alleged false statement, the name of any persons that witnessed it, read it, or received the alleged false statement, and when the false statements were made, and any documents relating to the alleged false statements. Um, I think this case is close to 5 years old right now. I know there's another one going on that's on its 10th year. These are very long, drawn out cases, and so because of that, I always tell shops that that sounds good. And some of them are like, well, I'm going to get my attorney to fire off a thing back to this adjuster that tells them I'm going to sue them for this. It's not really effective, right? Like it's not like there's an adjuster going, oh my God, we just got a letter. I better stop telling people they may have out of pocket expenses. So because of that, you're going to deal with this frequently. And when I'm asked by shops, well, what do I do? How do I fight back or whatever? I kind of just tell them it's not your fight, not your circus, not your monkey, right? If you have trained your customer, if you have had open communication, if you have done what you should do, then you're not going to have a problem. And so this is a great example of what a customer writes back based on that voicemail. So in other words, I always adjusters, once you put it in I don't want to say writing, but a voicemail is probably worse than writing. Once you write it down or once you say it, you now have to support it. You said it. Like you said, I'm in charge of, I'm the one that's going to review, I'm doing whatever. You said all of that in that voicemail. And so this response from this customer is wonderful. It just says, Dear Lena, so she gave us her name. Thank you for your voicemail and correspondence regarding my claim. I would like to clarify some concerning allegations made about my chosen repair shop, as it is essential for me to understand State Farm's position to make an informed decision about the repairs to my insured vehicle. You mentioned that the shop has a reputation for charging for unnecessary repairs not covered by my policy. Could you please provide some specific examples of repair procedures that the shop has estimated in the past, which you believe do not align with industry standards? Additionally, I would appreciate it if you could reference the specific language in my policy that excludes such procedures, perhaps by highlighting relevant sections for my review. Given that State Farm supports iCar and has representation on its board, I believe it is reasonable to use iCar standards as a benchmark. iCar emphasizes the necessity of following OEM procedures, which seems a fair basis for determining the repairs required to safely return my vehicle to the road. I have thoroughly discussed the training, certifications, and expertise of the estimators and technicians at the repair facility responsible for assessing the damage and formulating the repair plan I approved. That's key. For you shops out there, stop writing estimates and turning them into insurance companies without fully going over it with your customer, and then part two, getting permission from them to submit that repair plan. All right. Could you please share the collision repair technical certifications you hold that instill State Farm's confidence in your ability to review photographs of my vehicle and determine the necessary repair processes? I assume that your role in this situation outside the normal claims workflow indicates you possess significant experience in repairing collision damaged vehicles, similar to that of my shop. Understanding your qualifications would greatly assist me in making the best choice for my vehicle. I look forward to your prompt response and appreciate your attention. That's a great that's a great customer, right? I think we all wish we could get a customer like that more often. But here's a customer that said, "Okay, here's all the stuff you said. I got it. I got the recording. You said you did this. You said the claim was assigned to you because you're an expert. You said you're going to be making the decisions. You said my shop doesn't know what they're doing. You said my shop charges for things that they shouldn't. Prove it." All right, like for every line on my shop's estimate, they've got a detail of why it's there. They can back each of the lines that are on the estimate with either an OE requirement or a part of the guide to estimating that says what is or isn't included. So now's your chance to do your job, right? If you're going to say something's not, shouldn't be done or isn't proper or is overwritten or whatever, back it up. Do you have the credibility? Do you have the training? Do you have what's necessary to make those allegations? That's really my best advice for how you handle this. Yes, it feels like steering, and yes, it even feels worse. It feels like torturous interference, but you have to accept the fact that the insurer does have a right to handle that claim. And that right includes explaining things to their customer, offering them alternatives of workflow and process. They can't tell them that we're not paying your claim if you don't do this. That's where you start breaking down and getting into steering laws and some other things. They can't intentionally do it just because they hate you. And I've seen some things get crossed lately where there are obvious things that the adjuster should be paying for and they're refusing to, and then encouraging the customer to move it to a DRP. Okay, that's crossing the line, right? Like if the fender's like in 27 pieces, you get a fender replacement. Like we shouldn't withhold what we know is owed on a claim to try to entice or coerce them to move. But if the adjuster has the right. They have a contract too. We can't interfere with that contract. We don't want them interfering with ours. We can't interfere with that contract either. So, because those things are difficult, I always just tell SOPs the best thing is to figure out a way to work around them. And the best way to work around that is your customer. You can't fight that battle. Like you can't get into it and call the adjuster and go, you can't say that, or you can't do that, or you can't prove that, because it's not between you and that adjuster. It is between that adjuster and that customer. And then we've just got to empower them and have them work in ways in which they can do that better. So always visit with your business attorney. By the way, every shop should have a business attorney on retainer. It shouldn't, I shouldn't talk to a shop and go, who's your attorney? And they go, we don't have one. Make sure you have one. You want to run these things by them when you feel like things are happening. You want to get them involved. They'll explain to you based on your state and history and case law or whatever, what is or isn't possible. They'll advise you that if you want to pursue this, it could get expensive and it could get long. I always tell most shops, if that average case is 5 years, that's 5 years that you have to, one, try to stay in business, and then two, pay all your attorney fees while all these depositions and all these things are taking place. And so if you don't possess that, then your best bet is to figure out another way around it and not to get too caught up in it. Because we could, my dad used to say, spit in the wind, and the only one to be mad because you're getting wet should be you at yourself, right? Like just just know that there's some alternatives. All right, so some other things to talk about on a Monday morning before you guys get out of here, and go back to work is, we released a 10-part human resources series for collision repair shops. And this is a huge need specifically for independents, but I can tell you that I've been in a lot of dealership-based shops lately that need some serious HR help. Um, if you have a single employee, right? If you're a business and you have just one employee, you need to be very aware of HR. If you have over a certain number of employees, you have to be very, 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 very aware. And usually that's like 8 or 9 employees. Check your state. If it's California, it's probably something loopy and way more crazy. But Wendy Kroll is an HR expert. In fact, she's another one of my State Farm buddies. So she was at State Farm HR for a long, long time, and I can tell you, you have not worked HR until you have worked State Farm's HR. It's quite special what happens to our adjusters and employees in the field. But Wendy now has her own HR consulting agency, and she is in California, but she works with collision repair shops, so she's got this down. So we went to Wendy and said, hey, body shops need just some overview help. And then we would hope that the body shops would engage Wendy's services to help them get their HR on point. We had a shop last month that was sued under liability for an employee injury it was a little over 2 million for an employee injury on their property using their own tools that caused the injury. And that shop wonderfully had a great handbook. They had documented processes and procedures. They had done everything correctly, and they won. And so I had really kind of prepared the shop going, hey, sometimes in these cases, the jury just feels sorry for somebody. And they get money, and it's not necessarily you did anything wrong. It's just that they feel sorry for the other human being. But they won a whole case. And so I was super, super proud of them. But it was just a great example of a shop that had all their stuff together. So in this 10-part series, it will go over an employee handbook and what you should and shouldn't have in it. Wendy will talk about some laws that some of you may not be aware of out there. So some of you actually are not in compliance with not only state laws, but some federal laws out there. What you can and can't do around recruiting, hiring, and onboarding. what you can and can't do around employee engagement. So we hear this a lot. People like employee engagement and making people stay and pizza parties and other stuff and creating a culture. And there are some things you can and can't do around that. So it's always good to know that. Harassment, what your requirements are. Not only just harassment within your employees, but as a business owner, I am responsible for judging and policing the contact of vendors with my employees. So that parts delivery guy, that paint delivery person, people that are coming and going from your facilities, you have a duty to check and monitor and make sure harassment's not taking place there. What can you do for performance management and what can't you do? And then what does the termination process look like? So I grew up in the body shop days where when you just didn't like somebody, you pushed their toolbox out into the parking lot and told them they were fired. Yeah, you can't really do that. Yes, most of us are in an at-will state, but there are some rules around that. And specifically, if you want to change things after you've hired somebody. So I see some of you shops, you go to like a 20 group meeting, you go to an association meeting or something, and you come back and you go, we're going to start doing this in our workplace. And there are some rules around that, right? So this is a great series. Hopefully, if you don't know anything about the basics of human resources, this is definitely, if you're a shop owner, this is definitely something you want to take and watch. And then my hope is that you are inspired to reach out to Wendy directly and let her walk you through. She has some templates for employee handbooks. She's been through it all. She's worked with individual shop owners. She's worked with multi-store locations that are not the large MSOs, but she's got that experience. And then I always tell everybody, if you can handle State Farm's human resources, you can handle anything because crazy stuff used to happen there, right? I have so many wonderful HR stories from the State Farm days. If you need us, if you have problems, if you have questions, well, you always know how to get a hold of us. You can always talk to Melanie. I tell everybody she's the smartest person at Collision Hub. You can send her an email. It's just melanie@collisionhub.com. And we will see you all soon. Thanks. Bye.